we're going to talk about something that's been in the forefront, not only in business, but in virtually all kinds of real estate for the past 4 or 5 years, since our real estate economy has virtually collapsed. What you're going to get today is some real nuts and bolts of how the system works and what we do to work the system. And further, let me introduce you to my team. There you are. My partner, Glenn Eckert, office manager, Michael Siraki, and Stephanie and Maria, 2 assistants. Dennis Lupo does research for us. And where's that? And Ed Schlager is on the road for us. Hi, Property tax appeals isn't really what it's connotated to be. It's about money. And it's about, in some cases, it's about some serious money. And if it's done, first of all, if you have a claim, the claim needs to be filed correctly. And we'll get into some nuts and bolts about that in a little while. We founded Professional Property Tax Appeals early 2008, basically when the residential market collapsed. It became a forefront. It was in the news, on the newspaper. Everybody's going to the board of review with their houses. Our background is real estate brokerage. I've been a real estate broker since 1978. And I'm going to pick on Dennis for example, had I sold Dennis a building in 1978, it was back before we had databases, believe it or not. We had to go to the city and pull the actual field sheets. But if he bought a building that was 10,000 square feet, it wasn't uncommon for me to discover that the city would be charging for 12,000 square feet. So in my commercial industrial, and some residential, I've been literally doing tax appeals for 34 years. So this is nothing new to me.
I'd like to add something real quick.
Go ahead.
To the beginning. It's extremely important to us that we're handling properties that are viable. It's a requirement of our business. It's part of our business plan. So what we do before we do anything is we analyze the properties to find out whether or not they actually can get a reduction in property taxes. And if we can't achieve a reduction, we let the client know. So it's a question of trying to find out first. You have to know that you're right before you proceed, because it can get expensive, and we don't like to waste people's money, and we will not charge someone for work that we cannot provide. So if you or you know of anybody that has a commercial building or a residential building or multi-properties, all we need is a list of the addresses, normally, in order to do a complete analysis.
Virtually second to none. And Mike Collins is in attendance today as well. He's a commercial certified general appraiser. A lot of times we'll look at the resources that we have available to us, and then if we have questions about it, then we'll flip it to one of our preferred appraisers. Again, we don't want to, our whole goal is to save people money, not spend their money. And it's worked out really, really well.
And that is a free service. Completely free.
Okay, what we're going to talk about today, our areas of expertise is, if it's got dirt attached to it, that's what we do. If it's residential, commercial, industrial, probably should talk about the difference in apartment buildings. Anything that's 4 units or less is considered a residential structure. Anything that's 4 units or 5 units or more is considered a commercial building. So you just might want to keep that in mind. We're going to talk about state equalized value. Taxable value. Taxable value is basically a new term. When we all voted for, well, I don't know if we all voted for it, but when we voted for Proposal A in 1994, that term never existed prior to. We're going to talk about the board of review. That's basically for residential properties. I know our focus today is commercial, but I'm assuming everybody in the room owns a home. The tax tribunal has been in existence for quite some time. We're going to discuss the idiosyncrasies and the procedures to get to the tax tribunal. Stipulations. Legal term, what it really means is you file a complaint and you try to work out a deal before you actually go to court. We'll talk about those in detail in a few minutes. We're going to show you some examples of things that we've done, and then we're going to show you some options that you've got available to you. I'm assuming everybody in the room owns real estate. In fact, I know they do. But we'll get to that. Then at the end, if you guys got any questions, we'll stay here until, we'll try to answer, first of all, we'll try to answer them. Odds are we'll be able to, and if we can't, we'll find out. In 1994, Michigan had a referendum that we voted for, or voted into, and it changed the way we view and tax real estate in the state of Michigan. Proposal A is an amendment to the state constitution. If you remember when we did that, our state sales tax was 4%. It went to 6%, but real estate taxes had gotten out of control. So what they did is they amended the way we tax our real estate. It used to be, 1993, if you paid $100,000 for a piece of real estate, you were supposed to be taxed at $50,000, 50% of the true cash value. Now what that's changed to is it's no longer your real estate specific is where the true cash value comes from, but it's a preponderance of like properties. That's where things have gotten really crazy. The other thing that affixed the term taxable value came into play because of Proposal A. The taxable, your state equalized value is what the municipality that you're located in is, it's supposed to be its true cash value. The taxable value is what your taxes are based on. So that's the number you really need to pay attention to for individual pieces of property. When we did Proposal A, the idea was to reduce taxes so people could still afford to keep the real estate. Personally, I was going to build a house. I had the blueprints done. We were ready to go. I took it to the assessor. I live in St. Clair Shores. I have a real nice spot on the lake. And the assessor looked at my prints and said, Harold, your taxes are going to be somewhere around $20,000. Put the prints in the archives and said, okay, I'm not building my house now. 3.5, 4 years later, Proposal A was proposed, and now my real estate taxes are about $8,000. So there was a distinct benefit that we derived from that. The idea was, over a period of time, your state equalized value was here, your taxable value was here. They were supposed to meet in the future. Nobody, myself included, anticipated the radical market decline we've seen in real estate in the South, in all of Michigan. One of the other things that Proposal A did was fixed the amount your property taxes could increase annually. Last year's factor was 1.7%. There was the consumer price index and the inflation factor. This year, you probably noticed when you got your notification of new assessment that your taxable value went up. That number is 2.7% this year. And it's legal, they can do it. The state equalized value, again, is a preponderance of evidence of properties that are supposed to be like yours. So where the assessor goes through and reviews it and establishes what the state equalized value for your property would be. Totally different from taxable value. That tax is determined. Let's just say we're talking about light industrial building, 10,000 square feet. If they've had, in your municipality, if they've had like sales of like buildings, 8,000 to 10,000 square feet, and they've sold for $30 a square foot, they're supposed to adjust your state equalized value to equate with current sales. We found in a lot of cases that's not necessarily what happens. It's little clip says, doesn't the market determine the value? It's supposed to. The way the laws are written is it's definitely supposed to, your state equalized value is supposed to be based on like sales of similar properties. Sorry, so you just, go ahead.
Over what period of time?
Good question. Tax year is January 1 through December 31st.
It's like values, period.
That is exactly in that time frame. Most municipalities have gone to a 1-year sales study. Used to be it was 2 or 3 years. And that benefited us when rates were, or when real estate values were rising. They've recognized, and to the benefit of all of us, that by you doing a 1-year sales study, it's more accurate, it's more timely. The question is if they actually do it. This is basically for residential. In fact, commercial real estate, it's a common misnomer. When you get that, everybody gets excited when they get their notification of new assessment in the mail. That's really not a tax bill, but it's telling you what's coming. On there, it lists days and times to meet at the Board of Review, strictly for residential real estate. And we'll talk about time frames and filing deadlines in a little bit. In the state statute, I do want to talk about this for a second. The State Tax Commission sets out guidelines for every assessor in the entire state of Michigan. What we find is their rules don't necessarily equate to the way the laws were written. You're supposed to be assessed, you're going to hear this a lot today. State statute, in fact, goes back to the original, the Michigan State Tax Act was drafted in 1892. We'll talk about 1893 in a minute. That was back in the days where we were still worried about big government. And I'm going to do my best not to get political today, but it's almost hard not to. You're going to hear true cash value a lot. True cash value is what we're supposed to be taxed on. Just one second. Go ahead. Just one second.
The what's happening today in the assessments divisions of these municipalities is they were completely, totally deluged with residential people complaining about their taxes. They loaded the boards of review. I mean, morning till night. They had to add additional days. That's dropped off tremendously because what the assessors have done is gotten very close to the true cash value on their assessments. You're still robbing people, but not by a lot, okay? Maybe $200 or $300 is what I see. Maybe $400 a year is what they're getting from you that they shouldn't be getting, but it's such a minimal amount that it's not worth the fight. By doing so, they addressed all of their attention to the residential property, single family, and left the commercial properties on the side, and left the commercial property owners into a position where if you don't ask, you don't get. And it's as simple as that. They are working on the assessments of commercial properties, light industrial properties, but they're not hitting the mark, and that's why we're here today.
Just by a show of hands, how many people own investment real estate in the room today? There's only, as do I. The only reason any of us own investment real estate is return on investment. It's a basic premise of why we buy them to begin with. There's only a couple of ways to increase your return on investment. We can raise rents, not happening in today's market, not with what I own anyway, or we can reduce expenses. One of the ways to reduce expenses is refinance a mortgage if you have one. Interest rates are at historical lows. The other, probably the second biggest bill that we all pay on our investment real estate is real estate taxes. And it's just always return on investment. Taxable value and changing market conditions. When the market changes, and our markets change radically, again, they're supposed to assess you on true cash value. We've got to look at the scale. Our value of our buildings have gone dramatically down. However, they still haven't adjusted the taxes where they're supposed to be in accordance with the law, again, with true cash value. You know, some people have the opinion that true cash value is what it sells for on the courthouse steps. Don't think about that, because that's not true. It's, again, a preponderance of like properties, and it's almost like the assessors use mass appraisal technique. They don't do property-specific appraisals on each one unless we force them to. So you're looking at, you could have a building that's, and I'll just use a light industrial building again, you could have a building that sells for $40 a square foot, and you could have some that sell for $20. Or even, I'm seeing $4 now, which is really ridiculous. But again, it's a preponderance and kind of an averaging of the total. Your SEV should follow it. What we're seeing now, and you guys probably saw it when you got your notifications of new assessments, your taxable value went up 2.7%. They're allowed to do that by law. What they're doing now is setting it up so you can't sell our buildings. They're raising, they can do whatever they want with the SEV based on their sales study. I just got my house, and again, we'll go back to my house. It's a real nice house. I finally got to be able to build it because they were going to tax me out of it. My SCV on my house went up $66,600 this year. My house didn't go up a penny in value. What they're doing is setting it up, at least what I'm seeing personally, and with the files that we bring in the office, they're setting it up so we can't sell our buildings. They're raising the SCV. What happens? I'm going to talk about that for a second. When you transfer a piece of real estate, the new buyer's taxable value is what your state equalized value currently is. And if you're looking at a big spread there, and buyers are sophisticated now. I mean, they've got a lot of choices. They know what their taxes are going to be when they acquire that building, and it affects value. It affects the value you receive for that property. There is a study that was done that in talking about residential property, 94% of the people that actually take their houses to the Board of Review don't pursue it further to the state tax tribunal. Assessors know it, boards of review don't know it. I'll use East Point as an example. Nobody gets any relief at the Board of Review in East Point because they know 94% of those cases are going to be dropped. Of the 6% that actually go to the tax tribunal, they either don't file something right, They don't show up. They don't produce documentary evidence in the required time frames, and we'll talk about that procedure in a minute. But they all know that unless this is handled right, they're gonna win, basically. Currently, it takes there's two segments, and we'll talk about it in a second. There's two segments to the tax tribunal. There's the small claims division, and we'll talk about the numerics on that in a minute. All residential goes to the small claims division. Then there's the entire tribunal. The entire tribunal, you're talking about claims that are in excess of $100,000. And it takes up to 3 years. We'll talk about the caseload that the tax tribunal's got. Well, there we go. Currently, there are 25,000 entire tribunal hearings pending. There are 55,000 small claims hearings pending. Look at the number here. There was only 14,000 adjudicated in 2010. These are the most recent studies that the state has produced. They basically have you on hold. And it's no different than any other court. Anybody that's been involved in any kind of litigation knows that it takes a while. There are only 7 entire tribunal judges. Of the 7, only 4 hear cases. Excuse me. By the way, I'm not a public speaker. If I stammer, it's just because it is what it is. However, in the courtroom, I don't drop a pencil unless I planned it, and I don't ask a question that I don't already know the answer to. There are 40 small claims magistrates, and 15 more started to begin. In fact, their training is the 4th week of March this year. Before that, there were only 15 total hearing referees that heard small claims. When you're looking at 55,000 cases, do the math. If they do 10 a day, it's years before they get that docket cleared up. What's really funny is they've taken on these new magistrates. They've heard a lot of cases. They've cleared a lot of the docket out, but they only have 7 clerical employees that do the filing on it. Now we get to court, and now we wait 6 months before we get the judgments back. And that was as of, the latest figures were September 30th, 2011. They still haven't posted them for 2012. This form is a small claims property tax appeal form. All residential, commercial, industrial that's under 100,000, well, 99,900 in dispute. This is the form that you fill out. It is so bureaucratic. You almost have to be an attorney to read it and fill it out correctly. It's redundant, and if anybody wants a copy of it, we'll certainly get one to you. There's fees associated with small claims filings, unless it's your principal residence. If it's your principal residence, there's no filing fees. For non-homestead residential, that fee is $125. Our queen, excuse me, I said I wasn't going to get political. Governor Granholm, one of the last things that she did was raise the filing fee for non-owner occupied single-family housing, rental properties, 500%. That fee used to be $25. Think they want to discourage landlords from going to the tax tribunal? You got 200 of them, do the math. This is an entire tribunal petition, and they've revised it, and they've actually revised it in a good way. It used to be 1 page, you stated your claim. Now there are provisions in here to expedite the petitions going forward, and it's now 4 pages, which usually when the government does add things to it, it muddles it up. This particular case, it's actually a good thing, and it should expedite entire tribunal petitions. Entire tribunal cases are based on the amount of state equalized value in contention. I want to go back to state equalized value and taxable value again. Unless there's been an error made or something's happened to your building, you can't argue taxable value. Everything has to be argued to the state equalized value. And your goal should be, if there's a tax appeal that's merited, to get the state equalized value under the taxable value. Then your taxable value reduces consequently, and that's what your taxes are based on. For fees of $100,000, for appeals of $100,000 or less, the entire tribunal filing fee is $250. For 101, it's kind of a ridiculous example, but up to $500,000 is $400. If you're appealing greater than $500,000, the fee is $600. The other thing that's different between a small claims petition and an entire tribunal petition is the small claims petition, if it takes a couple, 3 years to get it in front of a judge, there are no additional filing fees. With an entire tribunal petition, every May 31st, by May 31st, you have to refile for the subsequent year. It's half the original filing fee. May 31st is a very important date. If you don't file your petition for commercial, industrial, or apartments that are 5 or more units by the 31st of May, you've lost the entire year. That's an absolute D-Day.
Hold on one second. Go back to that other slide. This is a little confusing because it indicates here that it's $125 for under $100,000. Up here it's $250 for less than $100,000. The difference between those two numbers is whether it's going to be, you can take a case for under $100,000 to the full tribunal if you'd like to, but you don't have to. You can file it with a small claims petition, and by doing so, you save $100, $125, by doing it just on a different sheet of paper. Those little things come into play all the time for us. But our concept is to save our clients as much money as possible. The only problem we have, if we go with the small claims and then we get the appraisal back, and the appraisal comes in lower than the value, so you're reducing the value by, or the SEV by more than $100,000, we have to repetition and send in the additional fees. That does happen.
We try to be pretty conservative with our original, I'm not going to say guesstimate, because we do the research on it and usually we're pretty close. Sometimes we get fooled and the market changes radically. Again, light industrial buildings. Those buildings were $60 to $80 a square foot 4 years ago. Now they're between $4 and $40. So you kind of get surprised with that, and we may have to refile and adjust our position from a small claims to an entire tribunal hearing. And that's just a motion. It's not really difficult at all. There's no question. I've been doing this for years. When I go into court with a commercial industrial appeal, it almost doesn't matter what the value of it is. If it's $40,000 or if it's $500,000, we absolutely need a full narrative appraisal. Full narrative appraisals are expensive. However, we worked out a situation. I've seen them as high as $6,000, $7,000, depending on the complexity of the real estate that's involved. Mr. Collins, who I introduced earlier, because of the volume of business that we do, does full narrative, and he's great. He's very, very good at what he does, and his evidence package is paramount to mine and or your successes. You're looking at somewhere between $2,000 and $3,000 if we're talking for a typical commercial installation. We know full narrative appraisals. We study them, we earmark them before we go into court. In fact, a lot of times, documentary procedure says that we have to send the evidence package to our adversary, which would be the assessor in whatever municipality we're in, and they have to send their evidence to us 21 days prior as well. When we've got the right kind of evidence and we've got a real legitimate claim, we deliver real legitimate results. I don't even know, Glenn. What would you say is our average in entire tribunal hearings? How many do we stipulate versus how many we actually take to trial?
I think we're only going to take one of them to the full tribunal at this point. All the rest are in line for stipulations. We have established a very good relationship with a lot of assessors, and I know that a lot of people think that the only way to win with an assessor is to be adversarial. That's not true. We've created friendships with these guys. They understand what we do and that we know what we're talking about. So it is very possible, and for our clients, we'd like to move these as quickly as we can through stipulation. And of course, there's an argument there about values, but that's what we do best: argue values. We've been doing it for
all our lives. We're old guys. It is what it is. One of the benefits of stipulation, and let me break it down. We literally sue the municipality. So we're in tax litigation. I know you guys have all heard about people that have been in various kinds of litigation. The stipulation is basically working out a deal before you get in front of the judge. We've become really expert at that. It saves you time, saves you money, and typically we find we have a lot of clients that their businesses are either not there anymore or they're totally devalued. You know, it's just not like it used to be. And again, our goal is to get them as much relief as we possibly can in the shortest period of time that we can, contrary to some other people that do what we do. We'll talk about that in a second. Once an amount is stipulated to, that becomes your new SEV. Most cases, it also becomes your new taxable value. And it results, and we'll show you some examples in a second, it results in a lower tax bill. The stipulations save time, they save money, Again, with the question about the filing fees for consecutive years, reappraisals for consecutive years, and when you're talking about solid, valuable commercial installations, the expenses can be quite large. And we do our best to see that they don't get carried away.
One thing I can tell you about Detroit is that it has one of the highest millage rates in the entire country. And that was created when the Honorable Coleman Young was in office. He was a consummate politician. And what he was able to accomplish is that every 7 to 10 months, he would go to the people of Detroit and say, I need more money. I need a millage increase. And every time he asked for a millage increase, he got it. And he got it so many times that the taxable millage rate is $84.60 a thousand. Now, let's say you live in Shelby. Your millage rate is $26 a thousand. Okay.
And you can call 911 in Shelby.
If you have an interest in knowing what the millage rate is for a particular city, call us. Like I said, we offer a lot of free service. If you're going to buy a building, call us. We'll tell you if we can fix it after you close on it. You know, these are just free services that we offer, and we've got a lot of information that we can share with you for free.
I want to talk about default. Talk about the complexity, and I just touched on it, the complexity of the two types of petitions that are issued. I'm going to go to an example now. Does anybody know Stefan and Eddie Paul from Continental Lanes? They're at 13 Mile in Gratiot. This is their building. They've been there for 50 years. They finally got tired of paying their $100,000 a year in real estate taxes and employed a certified general appraiser to do an appraisal on their building and approach their real estate taxes. The amount in contention was in excess of $100,000. They had the real estate appraiser help them do the initial work on it. He was inexperienced, he was a good appraiser, inexperienced, filled out the petition on a small claims petition. I'm sorry, Glenn, turn this thing, you know it's 9 o'clock now. Filled out the claim on a small claims petition. John Johnson introduced me to Stefan Paul, and he goes, hey, I just got a letter from the tax tribunal, let me get it. So we had his girl go get the letter. We opened it up, it was a default notice. Every default, if there is one, has to be cured within 21 days. It was the 24th day. I sent it, and his petition needed to be revised because it was the wrong one. I sent a motion, sent the motion fee, the state denied it because we didn't file it within 21 days. It's just one example. Filing the wrong documents. You wouldn't believe the people that come to us that have waited for 3 years, realized that they didn't send the right documentation in and no longer have their appeal. Filing without the correct fees. Virtually every single person that comes to us that has been involved in the tax process, not every single, probably 98%, has sent in the wrong amount of money, and now they get defaulted. Failure to respond, they just talked about that with Stephanie. If you don't respond to a default notice from the state, and understand this, they go out all the time on a lot of appeals. They don't want you to go to court. It's just, their job is to make sure that you don't get where you're headed. If you meet, how many people come to me in June when May 31st is the commercial filing deadline? They lose another year. And when you're talking about $8, $10, $12, $15, $20, $40,000 a year that you're overpaying in taxes, the filing fees in the continuation fees are minuscule in comparison to the savings that can be had in a lot of cases. Council conferences. Once you file an entire tribunal petition, you've got 77 days to have a council conference with the city attorney and/or the assessor. If you don't do that, your petition goes away. 100% of the people I talk to, other than a couple of attorneys and some appraisers, aren't aware of that. If you send your entire tribunal petition in without what's called a proof of service, that's where you have to send to the school board, to the city the municipal treasurer, the supervisor or mayor, whoever's in the city. If you don't, it's a proof of service that you're filing suit against that little piece of millage that you got to send it to everybody that's on your tax bill, saying, okay, we're suing the city and you're benefiting from it, we need to inform you. If you don't do that, they kick your petition. So again, this is some of the nuts and bolts of filing an appeal that you really should pay attention to, and if you got any questions about it, we'll certainly do our best to answer them. Discovery period. It doesn't matter if it's a small claims or an entire tribunal filing. You have to send your adversary, which in this case would be the respondent or the city or the township in which the property is located, your evidence package 21 days prior to the hearing. They have to do the same thing. If you don't do that, you go to court, you lose. Plain and simple. The judge will say, no, you didn't send this timely, this case is over. The evidence package that you submit, if in fact, well, if we handle it in the unlikely event you get a bad ruling, but if you get a bad ruling, or a ruling that you don't agree with, there's a process called exceptions. Oftentimes it's confused with an appeal. It's really not an appeal, but it's similar. You're allowed to file with the tax tribunal, tell them why your adjudication was incorrect and what needs to be done to correct it. The caveat to that is you can only use the evidence you originally submitted. You can't introduce new evidence. So that 21-day, what you prepare to send into that evidence package is critical, not only for the hearing, but potentially what could happen after the hearing. Let me show you a couple of examples of things that we've recently done. Where was his building? Was it Romulus? Yeah, this is a late industrial building we did for Chester Limited in Romulus. It's 12,000 square feet. The original taxable value was just a little in excess of $500,000. When we were done with the assessor, she reduced it to the taxable value to 170. Now that was via changing the state equalized value. The taxable value is where the money comes from. So we reduced it to $82,975. It's not a whole lot of money. It's $5,371 a year. But Jeff had just bought this building, and he does heating and cooling supplies. He's planning on holding it for the next 20 years. The neat thing about Proposal A, and I talked to you about it a little while ago, is that taxable value can only increase by the rate of inflation, or 5%, whichever is less. Consequently, Jeff plans on being in business for 20 years. Over the 20-year time frame, that's what he's going to save. It's just the power of compounding, and everybody understands that. In your packet, there's a little commercial brochure. And by the way, all the people that I'm talking about today not only are allowing me to use their names in their examples, they beg me to. They're kind of tickled with what happened to them. Ray Barwin came to me in 2008, 2 little rental houses that he owned. And this is just a cute story. We did the 2 rental houses, got him his refunds, and he goes, Harold, I want to talk to you about my other properties. I said, your other properties? He goes, yeah, I've got 2 apartment buildings, and I think he's got 8 or 9 other single-family residentials. I said, Ray, why didn't you, we've lost years here, why didn't you bring these to me before? He goes, I don't know, I bought a lot of tapes and classes that I took that did me no good, and I didn't know you. Consequently, we handled Ray's apartment building in Mount Clemens. When we started with this, his true cash value was $1,170,000. We were able to, now we stipulated this file, we were able to get it to $1 million for 2010. Going forward to 2011, it's 51 units. We saved him $9,079 a year, and again, he's got no intention of selling those. It's going to stay with him for a long period of time.
When we originally talked to Ray about this building, he had purchased it, and he said, you know, I don't think you guys can reduce this one.
Yeah.
And he said, Ray, let's take a look at it.
About 7 months later, that's what happened. This was a assemblage on Auburn Road in Shelby Township. They were going to build condominiums in. Obviously, they're not going to build condominiums till who knows when. But when we took this one on, the city had it assessed at $1 million. We ended up saving them almost $15,000 a year. Now they're able to hang on to that piece of dirt. It's not an alligator that's costing them $1,300 a month, or it's costing them now $1,300 a month less than it did before. Marty's lawn care is a little, what's his building, maybe 4,000 square feet?
46, approximately.
It's on Groesbeck and Mount Clemens. When Marty came to us, and I'm not going to be redundant and read the numbers, we saved him almost $6,600 a year. Marty's got to cut a lot of lawns to make up $6,600 a year. Probably everybody in the room knows Vertical Vic. They've been a fixture in Macomb County for at least 30 years. In fact, I think it's 35. The building on Groesbeck when we met Vic was $1 million. We negotiated it down to $799. Consequently, he's paying $9,200, almost $9,300 less a year than he was when we met him. Now, all the files that you're seeing here did not go to court. It didn't take 3 years. The next one you got, I believe they're sequential. The Holiday Inn in Waterford. Great business plan. These guys positioned themselves right between Oakland Airport and Chrysler. Well, guess what happened? Nobody's flying in to go to Chrysler anymore. So their business model altered. They're currently paying almost $24,000 a year less in real estate taxes than before we met them. My accountant's building. He's got two twin, really nice buildings on Garfield, just north of 17 Mile Road. We redo, and that, for people that are landlords, all John's leases were triple net. All the tenants were coming to him to renegotiate those leases. We were able to avoid that because we reduced their common area maintenance fees by a total of $20,000 a year. So instead of less rent, we reduced his expenses. His tenants benefited directly by it because they're triple net leases. He's still collecting the same rents. I want to talk about, these are two real recent decisions that we did. And this is Jim's building on Joy Road, right by the airport. He was in the sign business for years. The sign business he kind of retired and phased the business out. This is a 60,000 square foot building. We settled in Harrison Township. His refund, we're talking about subsequent years. It took us 3 years to get this done, or nearly 3 years to get it done. The assessor in Harrison Township was a pain. His refund check was $46,000. Like we talked about Continental Lanes a little while ago. Once we got their problem fixed, filed it with the correct way with the state, and the assessor came in line. The city attorney is Tim Tomlinson over there. He's a great guy. He gets it. Their refund check will be, and the ink is still wet on this one. I just mailed it yesterday. Their refund check is going to be $28,900. Now I'm going to tell you what we cost. For a building that's over, I'll make it real simple. Our total fee is 25% of whatever we save you. Initially, depending on the size of the building, we take upwards of $1,000 in a retainer fee. That comes off to 25% when we're finished. Basically, that takes care of the people I introduced you to when we first started. Excuse me. Why we're in front of you is because we're tax advocates. Why you're here is because you own real estate. What to do now is a couple of things. What I recommend everybody in the room do is come to Glen or I, give us your property's locations, just basically the addresses, other than in the city of Detroit. The city of Detroit's database sucks. I'm going to need information on what your building really is. Your buildings. There's some choices you can make. You can do it yourself. I'm not even going to talk about that one. You can hire an attorney. Part of the package that you have today is a letter from Lynn Mason, local attorney in Mount Clemens. We have attorneys that come to us constantly to represent their clients in their tax appeals. The reason they do that is because of the fact that they're an attorney. They have to deal with the city attorney. If anybody's done any legal business in the past, and I'm not, if there's an attorney in the room, I'm not slamming the legal business. Don't misinterpret what I'm saying. But most attorneys, if they're charging a 33 or a 50% fee in billing per hour, they want to send letters back and forth to the city attorney. We want to go in and have them sign a stipulation. The happier we make you, the faster we make you happy, is why we grow. The other thing with reference to attorneys is I don't know if anybody knows Dominic Cusmano. He's a local internist. He lives in Clinton Township. His office is in Warren. His buddy, the attorney, filed his single-family house as an entire tribunal petition. So he paid filing fees. He's going to wait 4 years. I've since amended it, but he's going to wait 4 years. There was no fees to send in. It's a single-family residential principal residence. It's automatic. It goes to small claims, and there's no charge.
You might want to expand upon that letter. The letter that we've got from Lynn Mason, the attorney, basically is informational that her client was trying to get a quick reduction in his property taxes. The reason for that is because he was building parts for the tanks, U.S. government tanks, and they were cutting back on building these Abram tanks, and he could see that he was losing money. He had to do something to save his business. And when Lynn Mason took him as a client, she had to go through the city attorney, and the city attorney just happens to be the same city attorney in 5 other communities, not just the one that she was dealing with. And we've had dealings with him before because we do have to communicate with him. And when we call him up for our
Council conference.
council conference, his actual response to our request to talk about a reduction is, "You just had it. Click."
Then the city gets a bill for $250. just to give you an idea. And I'll put it out there. His name's Dolosky, and he's a municipal attorney. And you got to go around him and get to the assessor if you want to get it done. And it's just the way it is.
So she contacted us because she knew that we could go directly to the assessor, overstep that attorney without getting into any trouble that she would get into if she tried to overstep the attorney. So it's as simple as that. Because we're not attorneys, we have an advantage.
The other thing I want to talk about that is this particular property that Glenn was referring to and Glenn's letter is about is in Chesterfield Township. Dean Babb is the new level 4 in Chesterfield Township, and as crazy as this may sound, he actually appreciates us. He knows we come in with our guns loaded, with accurate information, and he's not getting a guy sitting there wasting an hour of his day whining because his taxes are too high with no proof to adjust them. And that's kind of what we do. It's not kind of what we do, it is what we do.
Dean Babb is also a very intelligent man. He was previously to taking this job as the level 4 assessor in Chesterfield Township. He was a tribunal judge, and that's where we originally met him. And when we contacted him and told him what was going on with Dolosky, he says, "Yes, I know." He says, "Never call him, come directly to me. I'm tired of him ripping off this community."
Okay, now we just slammed him really well and he deserves every bit of it. The other thing you can do is have us help. At the very least, let us look at your property. You may be taxed correctly. If you are, we'll tell you. We don't take a client unless we know we can help them. We actually have a file now that we're working on we didn't know. Guy came to us, he's got, what are his buildings in Taylor? I don't remember.
He's got some light storage buildings on Michigan Avenue in Taylor, I believe.
He had hired an attorney, and the reason he came to us is he got default notices in the mail. Had fired the attorney before he met us, but now we've gotten contacted from the state. We didn't get the original, we'll get this all figured out in the next day or so. But he's in default now because the attorney didn't respond to the default notice. He came to us, and prior to us realizing that he had retained an attorney who he had subsequently fired, now we just got a mess that we've got to fix. We find that with legal people all the time. If you get a traffic ticket, if you've got to sue the guy that lives next door to you, hire an attorney. This, unless they're real specific about it. And there are some good law firms that do nothing but tax appeals. Other than that, most of these guys don't know how to do it. The other thing, again, is to have us help you. Probably the biggest thing that we do is let you know where you're positioned and what we think we can make happen. At the very least, our relationship will let you know if you're being taxed fairly or not. And you can decide what you want to do from there. All we need to get started with the tax appeal is an authorization letter. Basically, it's a retention agreement. If you got an issue, the fellow in Taylor I was just talking about, he had called his attorney 7 times. It cost him $700. We don't do that. You want to call us, you want to email us. This time of the year, because we're crazy with filings, you may get a return email at 2, 3 o'clock in the morning. John Johnson asked me why my eyes were so red. I finished at 3:15 this morning, and then I was here. One of the other things you can do, regardless of what kind of case you have, and guys, please write this down, is once you are issued a docket number, it's so easy to follow it. The state's got a great website. You go to michigan.gov/tax-trib. Then you can look at, there's a little cursor on the right. You just click on docket lookup, and it'll let you know where your case is at with the state of Michigan. Okay, anybody got any questions? Hopefully we'll have answers. Yes, sir.
You mentioned from the outset that the initial thing that's coming up next week with all of the municipalities.
For residential, sir?
That was primarily for residential.
It is only for residential.
It is only for residential.
A lot of people take their commercial buildings there. We find it's a fruitful effort. The people that are sitting there are members of your community. Sometimes they're real estate appraisers. Sometimes they're loan underwriters. They try to get people that sit, well, depending on a municipality. Some of them it's just old boy network, and these guys get paid $107 a day, and they sit there and reject everybody, collect their money, and go home at the end of the 3-week period. But it's designed to have people that are actually cognizable, but members of your given community, that make a decision based on your presentation versus what the assessor has told you. That, for residential, you've got to go. If you don't go to the Board of Review, there is no going to the tax tribunal until the following year. But commercial, industrial, in apartment buildings, 5 units or more, it's not required to go. You can't file your commercial or industrial claim until the Board of Review has ratified your assessment for 2012. That happens during the period of March, and that's when the tax rolls are signed. So you really can't file. Our target date, the girls will tell you, I carry boxes of mail out of the office. April 1st, you know those, what do they call them? If it fits, it ships boxes from the post office.
Yeah.
Last year for residential, we sent 4 of them. Now each appeal is only 2 pieces of paper and a check. So you can imagine they're about this tall. How many we sent? But yeah, for your industrial stuff, I wouldn't waste my time.
Okay.
Yes, sir.
Well, wait a minute, I'm confused, sir. Isn't it better to at least submit something so you can go to the tax tribunal? You have to submit something to go to the tax. Maybe I didn't understand it.
Okay, maybe I was unclear. 4 units and under.
That's residential.
It's all classified as residential.
Right.
You must go to the Board of Review.
I understand that.
There are also 2 cities, Grand Rapids and the city of Detroit, that have another process for, again, for residential or 4 units or less. It's called the assessor's review. If you don't go to the assessor's review, you can't go to the Board of Review. If you don't go to the Board of Review, you can't go to the state tax tribunal. So they put up another little hurdle, if you will. Yes, sir.
One more, please.
Ask as many. I hope I'll be able to answer it.
Nothing's perfect. You guys do a wonderful job here. I appreciate it. But nothing's perfect. If you lose, what do you do?
I don't know.
You don't jump out a window. I mean.
No, that's a real good question. At the Michigan Tax Tribunal, which has no enforcement powers, if your case is denied, if you lose, and you go through the exception process that I talked about earlier, and you're unsuccessful there. We had a meeting on January 11th with Kimball Smith, who's the chief judge of the tax tribunal. He's it. And Peter Kopke, who's the administrative judge, because of 3 new small claims hearing referees that they brought on. My track record is 1,268 to 1. We took the 1 by mistake. It was a case, and I think we might have got another one. I'm sending his money back today. People went on, and this is residential stuff. They went online, signed up for our service, and we told him the other day we couldn't help him. He's just pissed off, and we can't. We got to make sure. Again, you got to make sure you got a case. The action that would follow, if in fact your claim is right, would be the Court of Appeals.
I'd like to expound on that. If your case has to go to the Court of Appeals, probably never should have been started.
Other
Should have
than,
been started.
let me piggyback off that again. The reason we had this meeting that was scheduled for 15 minutes with Kimball Smith and lasted 2 hours, we started with me calling, how do you prefer to be addressed? And it was Your Honor. After 15 minutes of berating us, which he thought we were there to complain. Kind of were. But on the same token, 2 hours later, it was Harold, Glenn, and Kim. And he goes, thanks for drawing this to my attention. We lost 47 small claims cases in a row because of untrained, inexperienced magistrates. The evidence didn't change. The respondent didn't change. The petitioners were different because there were different pieces of real estate. The only variable was the hearing referee. And they came up with crap that was unbelievable. When we pointed it out to them, all of a sudden, those 3 hearing referees, we don't have them anymore. And it's just worked out. The State Tax Act was drafted in 1892. That was back in the day when we were still concerned about what England was doing to us. The following year, they realized it because they put a taxation policy in play that it had the potential to be abused. So they drafted an amendment to the State Tax Act in 1893. What this says is if an assessor or a supervising board, which we now interpret to be the Board of Review, if they willfully assess any property at more or less what he believes to be true cash value, he should be guilty of a misdemeanor, and on conviction thereof he should be punished by imprisonment in the county jail not exceeding a year, or a fine not exceeding $300. How much was $300 worth in 1893? We've got 3 prosecuting attorneys in Wayne County that we currently represent with real estate that they own. They've dissected this, they've pulled it apart. Unfortunately, we can't sue people for doing this because of the way this was written. Shall willfully assess, where is what I'm looking for, Glenn? What he or she believes. There's no way to prove what somebody believes. And believe me, they're not going to change this. But it's still the law within what's required. And when we pull this out and throw it down at a board of review or in front of an assessor, the girl in Harrison Township is a classic case. They go, what do you mean I can go to jail? They actually say, you mean I can go to jail for this? Yeah, you better get it right. Plain and simple. I'm sorry, I just thought you guys might want to know that. Well, I appreciate everybody taking their time this morning, listening to an old guy talk for a while. Thank you very much.